May I please, Your Lordship? I beg to mention item number 16, Lordship. And on behalf of respondent number 6, Lordship.
Yes.
Let this matter is after vacation, Lordship.
Prayer made on behalf of Sir. List of revocation.
Highly blessed, Lordship.
I have a mention memo for tomorrow.
What for?
My Lord, in this matter, what had happened that the petitioner had filed a petition, civil revision petition for early disposal of the case. I have received the notice. The matter is likely to come by after 3 weeks. The court was pleased to. And we concede to same that we also intend that the matter should be disposed. It's a mad disposal because the trial court has not disposed the matter for the last 9 years.
Okay.
My Lord.
Inform the other side. You inform the other side.
Taking into consideration.
Yes. Yes, Mr. Jam.
My Lord, item number 8. My Lord. Item number 8, my Lord.
Yes.
My Lord, I pray that the matter will come after vacation. My Lord.
Your Lordship, it's a joint prayer, Lordship.
On joint payment with the parties, list of revocation. Yes.
Your Lordship, 7 and 8 are connected matters. 7 and 8 are connected.
Connected, my Lord.
7 also you were there?
My Lord.
Yes. They both are matters.
Highly appreciated.
Please, Lordship. Lordship, I'd like to make a mention for item 5.
Item 5.
Lordship.
Yes. When do you want?
After vacation, Your Lordship.
Who's the other side?
State, Your Lordship.
Yes. Item 5.
No objection. Lordship, 5 and 6 are connected matter, Your Lordship.
5 and 6.
5 and 6. Lordship.
Yes. Both the matters. This one prayer made by the
Highly
petitioner,
obliged,
not object to the learned GA pen with the state. List of revocation. Yes.
Obliged, Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 4.
Yes.
Your Lordship, I'm seeking some more time, Your Lordship. Let it be after vacation, Your Lordship.
They are supposed to file their written note of argument. This is
Done. Yes.
again and again they are taking time.
This will go after vacation, Mr.
After vacation, Your Lordship.
Tell me, this,
Yes.
there are
Let it be after
some
vacation.
problems also with the thing. So, anyway, we'll check. This is also same model. After vacation, prayer of the petitioner, not of the learned GA. Yes.
Obliged,
Your
Lordship.
Lordship.
May I please, Lordship? Lordship, I beg to mention item number 14.
Yes.
Matter may come up after vacation, Lordship.
I have an objection, Your Honor. Already considerable time has been given. Therefore, is my humble request
Is
if
it-
the hearing could be taken up.
This is a civil revision
Your Lordship.
involving what subject? What is the
This is a
subject matter?
is with regard to the marital affair
Marital dispute.
dispute, Your Lordship.
And what is the nature of dispute? This is a maintenance matter or
Maintenance.
any interim order by this court?
No, no.
Let it go after vacation. This also unfair of the pen by the petitioner. List after vacation. Yes.
Much obliged.
I'd like to mention item number 9 and 10.
Yes.
This matter may come up after vacation, Lordship.
No objection, Your Lordship.
And prayer made on behalf of the petitioner. List after vacation. Yes.
Please, Lordship.
Yes.
Lordship, I beg to mention this item number 2, Your Lordship.
Item number?
Number 2. This is regarding Akung matter.
Yes.
Oh, please, Your Lordship. All the time they are taking their time.
Yes,
my
Mr.
lord.
Hajarika, but then this will go after vacation. Now there is some difficulty on this part.
Today I want to finish my
Court will
lord.
have
Both the
to-
parties are present, my lord.
We are
The
having
court
some
will have to
difficulties.
again go and sit, continue the division bench. There is one aspect. Second of all, that we are having shortage of
Next week, my lord, please.
Let it
before-
come after holiday, my lord.
It will come after vacation.
Yes.
There is not.
Yes, Lordship.
Yes. Yes, Mr. Day. You
My lord, I have nothing to say.
there is some practical difficulty. That is. Yes. This is matter pending from 2017, isn't it?
There is no urgency, my lord. Yes.
Not urgency.
It is very urgent, my lord, because client people are
Just after
2017.
vacation, just after vacation,
Lordship, yes,
make sure
yes.
that matter is taken.
Yes, Lordship.
Then it may come on.
Much obliged. Much obliged, Lordship.
After vacation, prayer made. Number. After vacation. Yes.
May
Yes.
it please your Lordship beg to mention item number 12. Your Lordship, I'm praying for some accommodation in this matter, Your Lordship, praying that this matter may come up after vacations.
No objections.
12 after vacation and the prayer of the petition. Yes.
Much obliged.
May it please, my lords, I beg to mention item number 13.
Yes.
Joint mention. My lords, it's a joint mention.
13. I'll join prayer meet with the parties. District prayer petition. Yes.
After vacation. Great for my lords.
Please, Your Lordship, I beg
Yes.
to make a mention of item number 11.
Yes.
Your Lordship, similar matter is pending before DB.
It's a POXO matter.
This was after vacation. 11. Yes.
All right.
Your Lordship, right, Your Lordship.
May it please your Lordship,
Yes.
I beg to mention item number 15.
Yes.
Your Lordship, I'm praying for some time in this matter, Your Lordship.
Who is
I've
the
informed the petitioner counsel.
No objection, your lords.
Okay. 15 also. One prayer meet. Respondent. List after vacation. Yes.
Much obliged.
Supplementary cause list, item number 1.
Yes.
May it please your Lordship. I'm here under rules, under order 6 of the jurisdiction of a district council order 2014, as well under article 227. Here, your Lordship, I'd just like to give the crux of this matter by going into...
There is a caveat. There is a
Yes,
caveat.
My lord, only caveat.
Let us
has to be discharged first.
first discharge the caveat. Where is it? Just caveat discuss. 19. Mr. Sangma, you are appearing for the caveat.
Lordship.
Yes. This Mr. Sangma, Learned Counsel representing the caveator submits that a copy of the connected civil revision application filed by the petitioner, filed by the prospective petitioner herein has been supplied to the step. The caveat as such stands discharged by allowing the caveator to oppose the motion of the revision application. Yes. Yes.
Lordship, to get into the crux of the matter before this honorable court, I'd like to draw your Lordship's attention to the synopsis.
Yes.
Your Lordship, the respondent in May 2024 had filed a civil revision petition before the Court of the Judge, District Council Court, Shillong, under Rule 31, bracket 2 of the UK&J Hills Autonomous District Administration of Justice Rule 1953, against the order dated 9/11/2023, passed by the Learned Presiding Officer, Subordinate District Council Court, Shillong, in Miss Case number 77 of 2023. Now, the order dated 9/11/2023 emanates or arises from an application under Order 39.
How her revision lies?
Exactly, that
Order 39, Rule 1 and 2.
That's why I'd file
It's an appellable order, isn't it?
It's an appellable order under
Order 43, Rule 1R.
1R.
Yes. Yes.
Malon,
Oh, sorry. Well, your matter is against the order passed by the revisional court. The revision was entertained.
Entertained, and the merit of the civil revision was taken up when we are on the subject of maintainability.
Anyway, how first just say how it is maintainable, Mr. Sangma?
Lordships, we have filed the application under. Locally, can you have Lordship have the administrative justice rules?
Rule 32, isn't it?
Rule 31, my lord.
Rule 31, subclause 2.
31 sub rule 2.
That is the crux of the issue.
That's the crux of the issue. Instead of looking into the maintainability of the revision petition, the court instead have gone into the entire issue when we have not even.
The court has held that this finding is recorded, this is maintainable.
My lord,
Yes. It's very, in a very cryptic way. Your Lordship.
Yes, 32.1, yes. Read it. 31, sorry.
31 bracket 2.
Yes.
Court to pass orders on appeal authorized by law. The District Council may, by subject to the provisions of these rules, pass any order or appeal authorized by any law for the time being in force. The District Council may call for and examine the records of any proceedings of a subordinate District Council Court, an additional subordinate District Council Court, or a village court, and may enhance, reduce, cancel, or modify any sentence or finding passed by such court or remand the case for retrial.
Yes.
No, my lord, here.
He speaks about appellate power or the revisional power?
No, my lord, this is not about being a civil or criminal. Your lordship will see, my lord, the legislature in its wisdom has specifically enacted, my lord, and say that any may enhance, reduce, cancel, or modify any sentence or finding. As such, my lord, we have invoked the provisions of under Rule 31, sub Rule 2, in filing the application.
No, but then subclause 2 applies to a civil matter.
My lord, in my humble submission, my lord, yes, it applies to civil matters. No, my lord, since the
So may enhance, reduce, cancel, or modify any sentence.
sentence or finding, my lord, yes. The finding, my lord, is an expression, formal expression of a court.
Yes.
In fact, this provision is relating criminal matters.
That is what it apparently seems like.
That is.
Where is the provision? Where is the provision where it says the spirit of CPC will apply? This is rule
47.
47.
Rule 47.
See, rule
provides-
47 makes it clear, Mr. Sangma. You do not have to say these things. See, read rule 47.
My lord.
And I don't think you dispute that this is a civil matter, isn't it?
Pardon, my lord?
Are you disputing this is a civil matter, purely civil matter?
My lord, I'm not disputing.
So read together what 47 will say. You are probably, see, this initial passing of the injunction under order 13 rule 182, is there any dispute?
No.
Then where is the question of, even for the momentarily, if we assume that your submission is correct, how a revision will lie when appeal lies? You are ready for disposal today?
My lord, yes. Your lordship, I would just like to place the facts. My lord, prepare the list of dates and events culminating in passing the impugned judgment. My lord, I'll just place this.
You are not onto the merits
My lord,
of
yes,
anything.
yes, your lordship,
Will it be
before
very
passing it.
relevant? This court is basically concerned with the...
Because, my lord, here, your lordships will kindly have the injunction, my lord, the injunction order passed by the London Trial Court.
You are not on the merit.
That is, but then this is for motion, first time. It has come up for first time.
First time, my lord.
We'll see it on when these things.
Lordship, in the application I have sought a stay.
Yes, hard. Mr. B.G. Gintal, Learned Senior Counsel, appearing for the petitioner. And also Mr. Sangma, Learned Counsel, appearing for the Mr. C.C.T. Sangma, Learned Counsel,
My lord.
appearing for the both the respondents.
All respondents. The Dorbarshna.
Appearing for the respondents. Stop. Paragraph by this application. A challenge has been made to the order dated
14 November 2025.
14/11/2025
passed in CRP 1 of 2024.
CRP 1 of 2024 by the judge, District Council Court. Khasi Hills Autonomous District Council, Shillong.
No, Your Lordship. It will just be Judge District Council Court, Shillong.
Yes, oh, that's District Council Court, Shillong. Okay. Wait, what is the problem with Khasi Hills Autonomous District Council?
It is, these courts are within the Khasi Hills Autonomous District Council, but nomenclature is District Council Court, Shillong. Your Lordship.
District Council Court, Shillong. Court of the Judge. Court of the Judge, District Council, comma, Shillong. Or Khasi Hills, Shillong.
Khasi Hills?
Okay, Khasi Hills, Shillong. Do not say Khasi Hills Autonomous District, just Khasi Hills, Shillong. By which? Do not say by which, just write a full stop. By the imperial order, after full stop, by the imperial order for dated 14/11/2025, the learned judge, District Council, has entertained a revision application preferred against an order of interim injunction passed in an application under Order 39, Rule 1 and 2, read with Section 151 CPC. In Miss Case number, what was the injunction passed?
This case number 77 of 2023.
77 of 2023, arising out of the title suit number?
TS number 30 of 2023.
By the presiding officer, subordinate District Council Court, Shillong.
Presiding officer, subordinate.
Stop. Stop. The learned senior counsel. Give a paragraph, huh? Then it's a learned senior counsel appearing for the petitioner submits that the learned judge, District Council Court, has resorted to improper exercise of jurisdiction by entertaining the civil revision petition number 1 of 2024 despite the fact that there was available remedy of filing appeal against the order of injunction of the trial court. It is further contended that the Rule 31 subclause 2 does not contemplate any revisional jurisdiction on a civil court. And hence, the very exercises of jurisdiction by the court of the judge, district council, is without any authority in law. The learned senior counsel further contended the further contended that the learned judge, while passing the impugn order, has decided the entire matter on merit. Without first deciding the issue of maintainability, which was argued before. He therefore submits that the interim order, that the impugn order, impugn order is not sustainable in the eye of law, and requires immediate interference by this court. Paragraph, Mr. CCT Sangha, Lada Council Penko the respondent. On the other hand, supported the impugn order and submitted that the facts and situation of the case has to be taken into consideration for deciding the present petition. Step. Paragraph. Since the question of jurisdiction has been raised by the learned senior counsel appearing for the petitioner, and the contention and from the contention raised on behalf of the petitioner, prima facie projects a case of improper exercise of jurisdiction by the trial court, it is deemed appropriate at this stage to suspend the operation of the impugn order dated 14/11/2025 until further order. Sure. We'll have it for hearing after vacation.
My lord.
Much.
Yes. This paragraph as per to the parties. Yes, agreed to by the parties. Release this matter for hearing after vacation. And at the beginning, you just say at the first line, what you say, heard Mr. So and so. Then
Assisted by
yes,
so-and-so.
yes, Mr. Bijay Gintal, assisted by Mr. Wansong. Then just so and so this thing, and then you just say hence no formal notice is called for.
Much obliged.
Maybe changes bit here, there.
Yes,
Very
Your
much.
Lordship. Much obliged.
Obliged.
That is quite surprising. The court has not come across.
This is the first time, Your Lordship, in my 38 years of practice.
No? So that is a magic of Mr. Sangma.
Mr. Sama and Mr. Dengdo. Much obliged.
Item number 2.
May it please your Lordship. Lordship, I'm before this Honourable Court, my Lord, challenging the impugn order passed by the Executive Magistrate, my Lord, Williamnagar. An order was passed to execute a bond, my Lord. Being agreed by that, my Lord, I'm before this Honourable Court.
Bond in 107 CRPC.
Yes. Now 126 CRPC, BNSS, my Lord.
126.
Yes. So what has happened, my Lord? Here, the petitioners.
Is there any alteration or change in the new provision or?
No, I think it's same, my Lord.
126.
Yes, 126. Here, my Lord, there is no prima facie, my Lord, evident that there's a breach of peace and tranquility, my Lord. Apparent on the face of record, my Lord. Even if the application, my Lord, does not specify any incident that there is likelihood of breach of peace and tranquility, my Lord. Herein, in fact, what has happened, my Lord, the petitioners are the absolute possession and ownership of a plot of land, my Lord.
Yes.
And after 17 years, my Lord, they have challenged their possession and ownership before the settlement officer, challenging the pata, my Lord, saying that they had obtained a pata counterfeit, they have obtained a counterfeit pata and all from the district council, my Lord. That matter is still pending, my Lord. Thereafter, they also filed another application
Pending before the
as a settlement
executive
officer.
authority of the district.
No, settlement officer, my Lord.
That is the executive.
Yes, yes, my Lord. Thereafter that, my Lord, they again file another application before the executive magistrate under 164, my Lord, BNSS, saying that there is a likelihood of breach of peace and tranquility.
164 is corresponding to?
126, my Lord. No, it's for procedure adopted, my Lord. For
164 is what? What does it say?
It says that
BNSS.
Yes, my Lord.
This code has
It's a
no
procedure
idea.
where dispute concerning land or water is likely
That
to
is
cause.
145, corresponding to section 145 CRPC.
Yes, 145 CRPC, my Lord.
Anyway, then yes.
So thereafter, my Lord, what has happened, my Lord?
There are two proceedings, 107 and 145. Two separate proceedings drawn. Or
No, on the same. The only 164 is drawn, my Lord. 164 is drawn.
140, that means under section, okay.
164 is drawn, my Lord.
Oh, yes.
Thereafter, when order was passed, the executive magistrate, my Lord, has passed an order for.
So you have been asked to execute a bond
Yes.
in 164.
Yes, in 164.
Is there any provision for doing that in 164?
No, you had to adopt 126, my Lord.
See, 164 is for the purpose of declaration of possession, isn't it?
Yes, my Lord. That is my grievance, my Lord.
Executive magistrate can declare only the possession.
Yes. They have to see whether I'm in possession or not, my Lord.
Yes, that is what. Let us just see 164. What is the provision of 164? So this has nothing to do with 126. 107 is not coming here.
No, my Lord. But they have passed an order to execute a bond, my Lord.
Under?
But they have provision is not mentioned.
Their very exercise is under 164, isn't
Yes,
it?
exercise under
So it does
164.
not mean that this has to be under 126. This will be an order under 164 only.
Yes. But herein, my Lord, what has happened is that I'm in peaceful possession of that plot of land, my Lord.
That is all
since
right. See,
17
we
years.
are, if we see, like, so far as the factual aspect is concerned, it's very difficult for a revisional court to
Lordship.
decide it. And you know limits of
Yes.
jurisdiction. We will not go enter into these things. But then if you can show that, yes, order passed under 164
Yes.
is grossly illegal, then definitely
No,
you have
because under 164, I am required to file written statement, my Lord. That is a mandatory provision.
Just tell us first. So here it is 164 statement. Now tell us when was first notice issued to you. in this
Notice was
proceeding.
issued to me
You
on
are, you are second party.
Yes, there in that proceeding. I'm the second party, my Lord.
Now was there filing of FIR, counter FIR?
No,
or
no
something?
filing of FIR. They simply file an application before the executive magistrate.
filed.
They filed it, my Lord.
For
So
doing a
thereafter
proceeding.
a notice was served upon me to appear before the executive magistrate, my lord. Thereafter that, my lord, the counsel.
Just a minute. Where is the first order? The very first order by which you were summoned.
Yes, my lord. Page 55, my lord, annexure 8. If I may be permitted to read, my lord. You are hereby directed to appear before Executive Magistrate East Garo Hills, William Nagar, in connection with petition filed by Srimati Rune G. Moment, Nokma of Baisajik on 12/11/2025 at 11:30 am. This office has received a petition from Srimati Rune G. Moment alleging illegal occupation of approximately 301 bighas of land under Baisajik Akang, wherein the allegation pertained to Srimati Ojoni Marak and Srimati Priya M. Sangma, Sri Isaac M. Marak, and late Andrew G. Marak, who are reported to be in possession of fraudulent of counterfeit land patas purportedly issued by the Garo Hills Autonomous District Council. You are therefore directed to be present at the office of the undersigned to give your statement.
Where is the under what provision of law this order has been passed?
My lord, it's not reflected, my
It
lord.
is not reflected.
It's not reflected.
Then what happened? Thereafter you appeared.
Thereafter I appeared, my
You
lord.
filed your shockos.
No, my lord. I wanted to file my written statement, my lord. She did not allow, my lord.
Question: where is the question of filing a shockos here? First tell us under what law this order has been passed. And where is the order which you are impugning now? This also you have impugned. Have you impugned this order?
No, I have not impugned. I have impugned the last order, my lord.
What is the last order? This
Last-
order you have not impugned.
No, my lord.
What is the last order?
No, before that, my lord, I just wanted to bring to your notice of
Now tell us where is the order by which proceeding under 164 was drawn up?
They have filed an application, but that is why, my lord, it has not been even registered. This matter has not even been registered, my lord. And the proceeding under what provision of law has been adopted, that also has not been recorded here, my lord. That is why we are before this honorable court. There's gross illegality on the face of record,
So
my
you
lord.
are challenging this page 72 order?
Yes, my lord.
Annex 11.
Yes.
What kind of proceedings are going on? This is nobody knows.
And moreover, I just wanted to draw to your kind attention, my lord. Kindly come to page 71, my lord. Page 71.
Yes.
It says, my lord, under letter number, a communication was received regarding an inquiry into the alleged illegal occupation of land measuring 301 bighas at Baisajik Akang by so-and-so, based on a petition filed by Srimati Roniji Momin, Nokma Baisajik Akang, Moza number so-and-so. In this matter, since only an inquiry is to be conducted and the case does not pertain to a non-FIR matter, nor is it being drawn under any section of the BNSS, the request made by the counsel of the second party in today's hearing dated 12/11/2025 to first register case under relevant section of BNSS does not arise. Accordingly, the next hearing of the inquiry is scheduled to be held on 26 November 2025. Note, my lord, 26 November.
Now, if say supposing you have not understood, if you say that this is that your request of registering a case under appropriate case under BNSS was refused, then the very question comes in: what basis this executive magistrate exercises jurisdiction?
That is what, my lord.
No, but then you are the second party, isn't it?
I'm the second party, my lord.
Then what prayer you have made to register a appropriate case under BNSS?
No, we went there, my lord, verbally making a submission before the court.
Okay.
My lord,
So your contention was that
will
until
appear
unless there is a case under
Yes.
BNSS and all, you have not. Just hard, Mr.
And moreover, my
I
lord,
do not know what is going on.
moreover,
here.
my lord,
See,
the date was fixed on 26,
If
but the order
lawyers
has
are-
been passed on 25th, my lord.
if lawyers are appearing in a proceeding before executive magistrate, okay, we understand that they may have difficulty in appreciating the provisions of law. But lawyer for guidance. You see, it is not that the lawyer is appearing for only one side. This kind of orders very.
And moreover, the date was fixed for 26, order passed on 25th, my lord.
We'll see into all those things. Let us first see on what very basis. You see, the law requires that if a proceeding under 164 is to be initiated, there has to be an order
Yes.
showing
That
the
there-
apprehension of breach
Yes,
of
yes,
right
my lord.
in relation with possession of land.
Yes.
That is what is the requirement of law is. So until unless that is done, no proceeding can be
Yes, my lord.
initiated. Any subsequent order will be illegal. Anyway, heard Mr. Moment Learned Counsel appearing for the petitioner. issue notice, returnable in 3 weeks. The petitioner shall take steps for service of notice upon the. How many respondents are there? Oh, you are for the petitioners. There
Yeah,
are so
for
many
petitioner.
petitioners. Okay. There is only one.
Yes, one respondent, my lord.
The petitioner shall take steps for service of notice upon the respondent within 2 days.
There's a miscase also, my lord, posting.
There is a miscase, separate
Yes,
miscase.
separate miscase, my lord, posting.
Why separate miscase? Could have made a prayer here. Any in a miscase, come miscase number 84. Hard. Mr. Sam, moment, also for the applicant. Come on, what is that? What is application? The applicant has sought for stay of operation of impugned order dated 25/11/2025, passed by the learned executive magistrate, East Garo Hills District, William Nagar. In what?
There is one, my lord. There's no case registered also, my lord. Just an order.
That is at page 70.
That's at page 72, my lord.
What is it? Just last.
Memo number is there, my lord. Memo number is there, my lord. Each.
Communicated right memo number. You just see from page 72 of the petition. Okay, there is a memo number. Okay. You do not say operation of the impugned order. It's impugned notice. This is notice. Nowhere it says. Communicated by memo number so and so, isn't it? This memo number also should be reflected at the top. Impugned notice. Issued by memo number so and so dated. Okay. By the so and so. The last part is not required to be given. The memo number will be given at the beginning. You got my things? Alright. Yes. Stop. It is submitted by the learned counsel for the applicant, paragraph learned counsel applicant, that the issuance of the impugned notice is totally arbitrary and illegal inasmuch as the said notice called for execution of a peace bond under section 164 BNSS by the petitioners. Stop. He submits it. At no point of time the learned executive magistrate had ever initiated any proceeding under 164 BNSS against the petitioners, and hence the passing of the impugned order is without any authority. The learned counsel therefore prays that the impugned notice may be stayed. The operation of the impugned notice may be stayed. Paragraph. Upon hearing the learned counsel for the applicant and of perusal of materials of record, it appears that no proceeding was ever drawn up in the matter by the learned executive magistrate before the impugned notice dated 25th November 2025 was issued to the petitioners. There is also no instance of any report basing on which the executive magistrate came to a conclusion. Basing on which the executive, but then there is an inquiry, isn't it?
No inquiry was conducted, my lord.
Then see the notice. It
Yes.
says during the course of inquiry. You do the second line you don't give. Just first line just say, because otherwise there is we do not know whether invalidity was there or not. But then there since the order says.
Yes, the order says.
We will go by whatever
yes,
it says.
Yes.
Just give it this line. Give up that line. Erase that line. Just read the previous line. What was there? No proceeding was due in under section 164 BNSS. Okay. Then stop. Hence, prima facie it appears that the order passed by the executive magistrate the notice issued, not order pass, notice issued. Hence, prima facie it appears the notice issued without any notice issued by the notice is without any authority. No. Stop. Consequently, the operation of the impugned notice dated so and so issued by memo number shall remain suspended till the returnable date. Let us see what the other side says.
Watch. Item
number 3.
Yes,
It's not cheap.
This is against Jimma application was filed before the Planet Court of Special Judge NDPS Rivoy District. Lordship, white order dated 22/7/2025. That is at Annexure 5 of the petition, page 24.
Yes.
The said application had been rejected, Lordship.
Yes.
Yes.
That
So
is,
they are-
this is a petition seeking Jimma of
Jimma of a vehicle.
what kind of vehicle?
Vehicle, it is a pickup.
Okay.
Pickup, his vehicle number is 1909 TR05 F1909, and it was seized during a Naka
Okay.
at the Umyam, under the jurisdiction of Umyam PS.
Yes.
It was seized on 24/7/2024. So
It was seized in 2024.
24, Lordship.
You filed application under 1 year.
After 1 year, Lordship, the matter has been charge sheeted.
Okay.
The owner of the us and owner of the vehicle, the application is filed. He is not named in the.
You are the registered owner.
Yes, I am the registered owner.
And are you an accused also?
No. Therefore, this application has been filed, which was rejected. So, Lordship, as an owner of the vehicle, the petitioner has a right to get a Jimma of the vehicle, even if it is the vehicle is seized in connection with NDPS case. The lying of the vehicle in the police station without any care will further damage the vehicle. And if even the vehicle,
What the law says? What is the law with regard to
the if the vehicle is involved, Lordship, section 60 says that it could be confiscated at the end of the trial, but the trial will not be concluded so early.
So there is a provision of confiscation if your vehicle is involved in the NDPS case.
Yes, Lordship, it's
Then in such
section
a case,
60.
the normal procedure of Jimma may not apply.
Lordship, it may, but keeping the vehicle will also not be will not benefit anyone, Lordship. Rather, if it is
See, we are in a revisional jurisdiction. We'll just see whether this order was passed by properly exercised jurisdiction or not. Now, if you say that this order, rejection order, could not have been passed because of some law, then we entertain it. If it is not, then we do not entertain.
The order, may take the Lordship to the order.
Just simply because any other view is possible, that may not be a ground.
Lordship, the rejection was not on the ground that the vehicle is liable to be confiscated. It is only said that
You have a decision of release of vehicle in NDPS cases.
Yes, Lordship, I have two decisions of this Honorable Supreme Court. This was recent only.
Yes.
That is of Tarun Kumar
Mr. Sheikh,
Majhi.
you are ready for hearing?
Yes, Lordship, because I have received the instruction, because what the ground they have, the prosecution has taken in the learned court below, Lordship. That is the same instruction, Lordship, here. I have received. Is that right?
Lordship, I may take Lordship to the decision, Tarun Kumar Majhi case, as
Dinesh.
para number 3.
Not, this is Dinesh.
Dinesh is another one.
So you have given furnish as Dinesh. Okay, there are two decisions.
Another two decisions.
Yes.
Lordship.
Tarun Kumar Majhi.
Yes, Lord. It para 3.
Yes.
It is pertinent to mention that the aforesaid vehicle owned by the apparent advocate was seized in 2017 in connection with investigation of a case registered under such and such PS,
Yes.
such a number.
Then?
Then that vehicle Jimma was not allowed to the owner.
Yes.
Para 13.
13, yes.
Recently, this court in Biswajit De versus the State of Assam Criminal Appeal number 87 of 2025, dated 7th January 2025, has held that there is no specific bar restriction under the NTPS Act for release in the interim of any seized vehicle. Since the respondent state is unable to give any definitive timeline as to when trial against the fifth accused would conclude, this court directs the trial court to release the vehicle in question after preparing a video and still photograph of the vehicle, subject to the appellant furnishing a surety bond of 2,10,000 instead of 6 lakhs. This court is further of the view that to direct the appellant not to sell the vehicle till the trial
these are
concludes.
conditions.
Yes. Against the fifth accused would be extremely unfair, as no owner can be directed to possess and own the vehicle indefinitely. Consequently, it is clarified there is no restriction on the sale, transfer of the car, and in the event the trial court ultimately passes an order of confiscation of the appellant's vehicle, the appellant shall pay an amount of rupees 2,10,000 only, as even if the estate were to sell the vehicle in question after confiscation.
Is it not that, by passing this order, the liability of the owner was made limited to the 2,10,000 only?
Lordship here.
Now, the law basically contemplates the confiscation of vehicle. And that is not on the basis of the market value of the vehicle.
Lordship.
Isn't it?
This case is slightly different, Lordship, here. In this case, what happened, two vehicles are involved, Lordship. Because...
For how long this trial is pending here?
My Lord, here the driver is yet to be arrested. Even several notices were issued to the owner of the vehicle. Because the prima facie appears that the owner of the vehicle is also involved in this case. Why, my Lord? Because he has modified the vehicle and he make a secret place.
But then have you made him an accused in the...
My Lord, that is the instruction, Lordship. That is why several notices were issued.
The instruction will not...
No, several notices were issued. Since prima facie found that his involvement is there. Because he has modified the vehicle. Because without the consent or connivance of the owner, that modification cannot be possible, Lordship. So he made a secret place where the contraband was kept. And because the driver could not be arrested, Lordship, because they have abandoned the vehicle and they fled from the spot, Lordship. Now the police have filed the charge sheet. That was not the final charge sheet. Because the final charge sheet will be filed after the arrest of the driver of the vehicle, Lordship. Now several notices were issued to the owner of the vehicle, but he was not...
This is a huge recovery of marijuana.
Yes, Lordship. Now only driver of the other vehicle was arrested. I'll just read out that only two sub-paragraph, Lordship, from my that instruction, Lordship.
Wait, just a minute. Just a minute, we'll continue. Yes, Mr. Sheikh.
My lord, here, finally, after thorough examination of the vehicle, the only possible way out to take out the whole contraband was to cut the upper portion of the manufactured floor, which led to the recovery of 22 packets of suspected contraband fully packed in brown tape from the vehicle number so and so. Now, last lordship, however, the absconding unknown driver of the vehicle number so and so is still evading from arrest, and the owner of the said vehicle, Sri Ratan Dabbar Masan of so and so, strongly involved with this crime, as such modification of the special hidden compartment of the truck knowingly done by the vehicle owner to commit the crime. The owner of the vehicle has been several times issued with notice for appropriate appearance, but did not comply with and also did not produce the driver of the said vehicle. The seized vehicle is still required for further investigation of the case. The supplementary charge sheet will be submitted after the arrest of the co-accused person involved in the incident case. That means that the investigation is still underway.
When was notice issued to the owner?
My lord, here they have not specifically mentioned, but only mentioned that several times.
How can general statement would be entertained by court? Whatever you say speak on the basis of the record. And the record should show it. You are not saying anything from your personal knowledge, isn't it? Then
true, lordship.
that is required. When you have instruction, you must ask for complete instruction. Yes, Mr. Upadhyay.
Lordship, the petitioner herein has never received any notice, and he had given this vehicle to the driver on a weekly basis payment, that he will pay 5,000 rupees. It is mentioned in para 3 and para 5, Lordship. When the vehicle has not returned in the month of July for almost 2 weeks, then he had went to the nearest police station, that is Mandai PS Tripura, to report that his vehicle is missing. They have noted down the vehicle number, and thereafter the police had informed there that vehicle has been seized in this here in Ribhoy, in Meghalaya, under an NDPS case. And thereafter,
The vehicle was seized on which date?
On 24/7/2024.
And when did you file your missing report, missing of vehicle?
Missing report, they have not taken any missing report. I went to report it. They said that they have noted down the phone, the vehicle number, and they come to ask to come after few days.
What basis you substantiated that?
Lordship, it is mentioned in para 5 of my.
That is your petition.
Then they have informed the police. Through police, I stated that I have come to know from the police there that vehicle has been seized in Ribhoy district, and I have never received any notice.
Yes, anything more, want to say?
And Lordship, the vehicle is under finance, which is at annexure 2. Will show that the vehicle is under finance of that company. So that liability is also there on the owner of the vehicle to clear the amount, loan amount.
What the Dinas says, that decision of Dinas?
Dinas, Lordship. Para 3, Lordship.
Yes.
The appellant herein has approached this court through the appeal by special leave for assailing the judgment dated 20 December 2002 passed by the learned single judge of the Madurai bench of the Madras High Court in criminal revision MD 1021 of 2022, whereby the prayer made by the appellant for interim custody of his lorry bearing registration number so and so was rejected. Para 5. Being aggrieved by the continued seizure of his valuable transport vehicle, the appellant moved an application under section so and so, being criminal miscellaneous application number so and so, before additional district judge, presiding officer, special court under Essential Commodities Act, seeking interim release of the seized vehicle on super dagi pending conclusion of the trial. So that was rejected, and he had approached before the High Court, that also had rejected. The para 2035. In view of the above, while the present case may technically correspond to the second proviso as enumerated in para 29 of Biswajit De Supra, the peculiar factual matrix warrants a more pragmatic approach. It would therefore be expedient in the interest of justice to grant interim custody of the vehicle to the appellant, as the overall circumstances clearly indicates his bona fides.
Where is Biswajit the case?
Biswajit, the case has been referred.
In both the cases, Biswajit Dev was referred. So where is that?
The Biswajit case, para 34, that some points, guidelines are there.
What is the difficulty in placing Biswajit Dev before this court?
It is a bit lengthy.
Or it doesn't support you?
It supports since those cases are relied upon. Para 36. In wake of the decision made herein above, the appeal deserves to succeed. The impugned judgment dated so and so passed by the High Court is accordingly set aside. The vehicle bearing number so and so shall be released on superdagi to the appellant on such terms and conditions which the special court may impose. The appeal is allowed accordingly.
No, we want to know what is the second scenario delineated in Biswajit case. Paragraph 34 refers to that only.
34, yes, it refers.
Although in superficial, on a superficial reading, the present case might appear to fall within the second scenario delineated in Biswajit case. So let us, where is that second scenario, and what is that second scenario you want to know? Come with the decision, Biswajit.
Lordship.
Mr. Just see.
Yes.
We'll have it on Monday.
Monday.
Next Monday. Hard-landed counsel paying for the parties. Stuff list again on, give Monday's date. to enable the learned counsels to produce authorities in support of their respective contention. Yes.
Okay.
Item number 4.
Good afternoon, Lordship.
Yes.
Shall I bring the court up to speed as to what I had, with regards to what I had stated before?
What is the case? Is it ready for hearing now?
It is ready for hearing, Lordship. Lordship, I had impugned an order. Impugned an order which is at annexure, which is annexure 1, page 11.
Page?
Page 11. Now, what I had contended, Your Lordship, was that the bail of the petitioner was cancelled and she was not given an opportunity of hearing before her bail was cancelled. It was cancelled on the same day of the filing of the application by the prosecution. May I read, Your Lordship?
Oh, this is that NDPS matter?
Yes, Your Lordship.
Yes.
Please, Lordship.
What will say?
Lordship, I have 3 submissions to make in response to my learned friend. The first submission is apparently in the petitioner in the same case, the first case that we're talking about, to which the impugned order belongs, had actually filed a subsequent bail application which was rejected. So in a sense, this bail application, Lordship, the impugned order, becomes non-est. The case has actually moved on. There's a subsequent bail application.
You want to say, after passing of this order dated 23/9/2024,
Lordship,
there was another application.
there was another bail application which was rejected in the same case. If I may, Lordship,
I have.
No, but then have you made a disclosure of that here?
It's not in the petition, Lordship.
No, have you made a disclosure?
About me filing an application post the cancellation in the said case? Yes, Your Lordship, I have. I said when I was moving the application on the 3rd of October, I had come to know that.
No, when you have, where you have mentioned that you have filed an application?
If it regards to the case in which the bail was cancelled?
After 23/9/2024.
Yes, Your Lordship.
You did file an application before the trial court, isn't it?
I did. In the case which
Where have you mentioned it in your petition here?
No, Lordship, but I
Why?
brought the order.
Why?
Lordship, there are 2 things for this. Let me just...
No, why there is no mention of that?
So, because the reason for that is when a bail is cancelled, there are 2 alternatives left. The 2 remedies left. One is moving a subsequent bail application in the same court. One is obviously moving an application for quashing of the said order. So, when I move an application for quashing of the said order, we examine the propriety of the order impugned. Necessary not.
Was it not necessary for you to make a mention that you have filed an application?
But I do not
Please
deny
give
at
us
the same
details.
time.
No, this is something. See, nowadays, even in bail application, there is a, I think, format of declaration where you have to make a declaration.
That was not
for,
here, Your Lordship. And I also have a copy of the order.
That is you are producing it now after the learned GAS.
No, I never disputed that.
The entire order sheet, Mr. Day.
Lordship, page 35, this is at item 4. There's the order rejecting the bail in the same matter, the subsequent order. There's an order dated 28/10/2025.
Page 35.
35, Lordship. Handwritten, page 35.
Order dated 28/10.
2025, Lordship.
25. Now this rejection was in 2024, isn't it?
The cancellation was...
Oh, sorry, cancellation was in 2024.
24. Suppose that I moved no bail application in pursuit of her being granted any subsequent bail in that particular case, but I did move an application as sir is suggesting.
This is something very bad. This court takes very serious note of suppression of material.
Lordship, the reasoning behind that, I'll let you know why I did that.
This is criminal NDPS 23 of 2023.
The bail was cancelled in NDPS 23 of 23, Lordship.
Same case, Lordship.
Yes, that is what. Just let us see what is there in the order.
Of course.
It's a long order.
It's a long order, Lordship, but I think the first 2 paragraphs and the last few will suffice. Shall I read, Lordship?
Which paragraph?
Sorry.
Mr. De, this order sheet pertains to that NDPS case number 23 only, or there are some
23
orders pertaining to some other case also?
This pertains to 23 of 23, Lordship.
The entire order sheet.
This is the entire order sheet for the bail on the bail application of the petitioner.
So that bail application was filed on which date?
28th of October 2025.
23/9, then 9/9. 9/9 bail application was there.
That was in the second case, Lordship.
So that is why this court has asked you. Second case means that is not 23. Second case is some other case.
It is a subsequent case.
That is all right. We are asking you about whether this order sheet relates to only NDPS case number 23 or not. We are not concerned about the other case now, right now.
Apologies, Lordship. But these are separate bail orders. So the order of 9/9.
See, we are not concerned with the bail orders of the other case.
Right, Lordship.
Kindly confine your submission to NDPS case number 23.
Please, Lordship.
Okay. Now just tell us what happened there. Now you want to say that even after the cancellation of bail,
Lordship.
they filed one bail application.
A subsequent bail application.
Yes.
Which was rejected.
Which was rejected. What is the bail application and where? What is the bail application number?
Bail application
It's
number.
156 of 2023, Your Lordship, dated 28th October 2025. I have a copy. You've supplied to someone.
Just the order.
All right.
You should have enclosed all those things with your thing.
The
Now
reason-
you have everything. You were basically, you could sense that these things will be raised. This
I
is something
knew.
not very fair, Mr.
Lordship, for that I have reasoning. The reason is when we filed the criminal petition, there was
Reason for suppression, reason for not telling.
No, Lordship.
You are trying to justify it.
No, Lordship. When I filed the revision, I looked for the remedies which are available. So there were two remedies as per my research as well. And it said I can file a subsequent bail application post the cancellation. I did that. I did not get the remedy, of course. And it said if there are two options available. One is, of course, moving a subsequent bail application. The other is moving a revision petition. Then I moved the revision petition. Then also, so I was...
When you moved subsequently revision petition, was it not your
Perhaps
duty
it was
that you had approached the trial court also for grant of bail?
I
to
should
mention
have.
it.
For that, I apologize. But there was no ill meaning in that or no motive behind that, Your Lordship. Because I knew that he would
That
always
we do not
confront me
know.
with that.
Once some necessary facts are not mentioned,
Lordship,
some adverse inference always comes.
I understand.
That is what.
Perhaps even if it was
you
not
understand it,
intended,
that
then
is
also.
good enough.
Even if it was not intended, I can understand. But since it was revision and we were not asked to make a disclosure about how many bails applied, so it skipped, Your Lordship. Anyway, I knew that the learned government council would come up with
by this order dated
Yes, Your
2810,
Lordship.
Mr. Dev, 2810, this prayer for bail was rejected.
Was rejected, Lordship.
So then what happens if can we pass any order now?
I believe it becomes non-as.
Now, say supposing, now it will give rise to complicacy.
Absolutely, Lordship.
Now, an order which was passed prior to 2810 has been assailed here. Now, say supposing we accept their submission, we allow it. Then what will happen to this order dated 2810?
Precisely, Lordship. We have moved on.
Take them.
Understood. Should have.
That is good enough. That you have suppressed. That is good enough. We're rejecting your application because of that.
Lordship, but it may be reflected. I had not enclosed. There was no meaning to suppress, of course. I should have impugned this order
You have
instead.
created a whole lot of problem. Now,
Right.
what would happen to the status of order
I
dated
understand.
2810?
It would, yes. Should have
That is
impugned
very-
this order instead of both, actually, yes.
This, see, you have not come to the court with clean hands.
Lordship, as the inference may be drawn, I will not say comment on that.
Just
But
see,
there was
just
not.
this bail application. Oh, this application of 528 has been filed. 528 BNSS. Has been filed. Seeking quashing of an order dated 23/9/2024. Passed in NDPS case number
That's why they want to.
23 of 2023. Arising out of Clariot PS case number 37 within bracket 5 of 2023. By which bail granted to the petitioner by order dated
Cancellation
1/12/2023 was cancelled. A perusal of the petition shows that the petitioner has made disclosure of relevant facts till 23/9/2024, on which the impugned order was passed. Stop. The present application before this court has been preferred after a period of after a period of more than 1 year. More than 1 year of the said date of cancellation of bail. But no disclosure as to the development which took place in the matter has been stated in the petition. Paragraph. The learned counsel for the petitioner, while challenging the order dated 23/9/2024, has primarily raised the issue of the fact of primarily raise the ground of non-issuance of a notice to the petitioner prior to the passing of the order dated 23/9/2024. Stop. Paragraph. Mr. Day, learned GA. You are GA only, or
GA, Lordship.
GA appearing for the state respondent. Appearing for Mr. G. Landing was appearing for the state respondent. On the other hand, submitted that the petitioner has suppressed the fact of filing of a bail application before the special judge within bracket NDPS is joined the Hills District Cleariot. In the case, after the cancellation of the bail, which was rejected by the London Special Judge, but order dated 28/10/2025. He submits that such suppression should disentitle the petitioner from getting the relief paid before this court. Stop. Paragraph. Upon hearing the learned counsel for the parties and a perusal of the material on record, more particularly the order sheet of the NDPS case number 23 of 2023 of the special judge within bracket NDPS is Jayantia Hills Cleariot. It transpired that the petitioner had filed an bail application under section 37 NDPS Act (1985), read with section 483 BNSS for release of the petitioner on bail. The prayer for release of the prayer for grant of bail was rejected by the London Special Judge by passing a detailed order. Stop. The petitioner, there is nothing on record to show that petitioner moved any other forum, any other higher forum against the said rejection order dated 28/10/2025. Or do not say against, pursuant to the said rejection order dated. What we said, Jazz? Last time? rather prefer this present application before the High Court. Without disclosing the fact of such rejection by the trial court.
This should have been impugned rather. Is a technical.
The conduct of the petitioner, as such, appears to be not acceptable by this court. More particularly, not appears to the court in view of the fact established or in view of the settled legal maxim that those who seek security must come with clean hand. Stop. It also appears that the petitioner refrained from disclosing the existence of refrained from disclosing about the existence of the order dated 28/10/2025 before this court. In order to create an easy passage for challenging the order dated 23/9/2024, challenging the 23/9/2024. Such conduct of the petitioner requires to be discouraged. In view of the discussion I do, this court finds that the petitioner is not entitled to seek any relief. Stop. The criminal matter as such stands dismissed. There may be slight correction here, there, because normally dictation of the courtroom always carries with it some mistakes. So,
please, Lordship. Grateful, Lordship.
Your young lawyer, do not
No,
While
I
your
did not do
image
intentionally.
before the
I do admit one thing, Your Lordship. I should have impugned both the orders. Therein lies the mistake.
could have
That is
prayed.
what-
You
yes.
have not made any prayer for doing that.
Lordship, I knew that he would come up with this, and I would have never. But yes, I should have made a mention about it in the petition.
And you have not made any prayer for doing that also.
No. Some technical aspects. Yes. Great.
Whatever we.
I apologize as well, Your Lordship.
Daily list, daily list,
Good day,
item
Lordship.
number 1.
May please, Your Lordship. Your Lordship, I'll be filing my affidavit during the course of the day.
I have received the copies, Your Lordship.
This is item number?
1.
One, Your Lordship. Daily list.
Hearing list. What is
CMJ matter, Your Lordship.
This has come up for hearing. Why it is hearing list?
It is fixed for filing of affidavit.
It is in there? This is orders, isn't it? Order number 1.
It's orders, Your
It
Lordship.
is fixed for
So we are
orders.
dealing with which matter? Okay. You have come to daily list now? Okay. Sorry. We thought we are already there in the hearing. You'll file it during the course of the day.
It goes over there.
So we'll list it after vacation then.
Okay, Your Lordship.
Okay, Your Lordship.
Yes, Mr. Landed Council looking for the response number?
1 and 2, Your Lordship.
1 and 2. For number 3, there is no representation.
Number 3, Miss Langstay, Your Lordship, she's representing. But for number 4 till now, we don't know who to represent. But we have already taken steps.
Number 3 had entered appearance.
Yes, Your Lordship.
On okay. On order 11-9, isn't it?
Yes.
Okay. Just say none appears for the response number 3. Stop. Mr. Landed Council appearing for the response number 1 and 2. Submits that the affidavit on behalf of the said respondent will be filed during the course of the day. Stop. Paragraph in view of the submission. You may have to file a rejoinder, or shall we list it for? Or you may have to. You have to see first what is there, then only.
Yes, Your Lordship. We have just received the affidavit.
Oh, you have
so
received the copy?
we have just received it today itself.
Okay,
so
you will just say.
we'll have to go through then only.
Okay. Then you give a paragraph. Do not say in view of these things. As per to the parties, list is not ratification.
Much obliged, Your Lordship.
Much obliged, Your Lordship.
Hearing, item number 3.
My Lord, I will recall in this matter, my Lord, there was a query as to the, my Lord, percentage of, my Lord, reservation pertaining to the special category, my Lord.
Okay.
Because our
Specially abled.
my Lord. And for a long time we had been waiting for instruction, my Lord. Eventually I wrote to the higher authorities. I have received a, my Lord, letter just recently, my Lord. So in within a week time, my Lord, it's going to arrive, my Lord.
The instruction.
My Lord.
Yes.
Let them bring it back here.
Okay. On prayer made by Mr. Guru Learned GA appearing for this number. For the appearing for the statement number 1 to 3. You list this matter. After vacation, stop. It is expected that the learned GSL obtain complete instruction in the matter in terms of the earlier order of this court.
My Lord.
Order
Was there an
18,
order saying that?
My Lord.
Yes, sir.
You see, we have not checked the order sheet.
No, there is an order.
Order is dated 1803, Your Lordship.
Okay. That says that GS should.
Lordship.
In terms of the order dated
1803-2024, Your Lordship.
2024.
Lordship.
25 is gone now, it's 2 years.
My Lord. I wrote a very strong letter, my lord, because of the
You should have done it before. Now it should have been super strong letter, you see, like you are strong. This is a difficulty this court knows, because since this court was holding the office which you are holding now, and we have come across this situation many times. And only after sometimes you take drastic step, then the result comes. It happens. You say after vacation, then you say it is expected that the learned GA shall have complete instruction in terms of the order dates and so. By that time. Yes.
I'll oblige, Lordship.
There will be many orders. Can you write?